Good morning, everyone. Uh, First and foremost, I would like to introduce myself. My name is Chiradeep Basak. I am a research scholar at National Law School of India, University, Bangalore, and I'm also faculty at National Law University, Assam. Uh, and in this particular online national seminar on online teaching, learning issues and challenges, I wish to make my presentation on the first session, which is on academic integrity. Before I start my presentation, I would also like to thank, first and foremost, the organizers, so-called Women Librarians Association of Assam, as well as the LIS Links academic social networks for organizing this magnificent online national seminar in the wake of this pandemic. This is the new normal, I believe, even in academics. And we have to cope up with it. We have to go ahead with it. Secondly, I would like to express my heartfelt thanks to the presiding Honorable Chairperson, Professor Narendra Lahakar, who is the President of Indian Association of Special Libraries and Information Center. I would also like to express my heartfelt thanks to my co-chairperson here in this particular session, also my colleague, Dr. Topi Basar, who is an associate professor at National Law University, Assam. Now, in my presentation today, I would like to relate something which is, of course, part of academic integrity with legal research or legal scholarship. Now, let me make my presentation here in front of all of you, which is primarily on the challenges of plagiarism and this plagiarism software, to be very specific, in legal scholarship. So the challenges of plagiarism software in legal scholarship is something we are facing for quite some time. And in this particular paper, I wish to highlight very briefly about some aspects of plagiarism and how far it has affected the legal academy, even judiciary, and what are the limitations in the existing plagiarism software which we encounter as a legal researcher. Now, when it comes to the topic of plagiarism, as we all agree, I believe, on this part, that it has garnered increasingly. It has increasingly garnered attention, promoted by a veritable plethora of high-profile instances of perceived or even proven plagiarism, and the increased media attention directed to the outing of the malfeasors and the publication by the scholars or even the statistics, which usually demonstrates a growing inclination on the part of the colleges or even the university students to engage in variety of cheating mechanisms. And they all become very relevant in the current context, because the fundamental problem associated with plagiarism in any scholarship, it is not just the use of another's word or ideas, but when you pass them off as your own, that is wrong. I remember, there was this particular song by Tom Lehrer, where the lyrics goes like this: plagiarize, lets no one else works evade your eyes. Remember why the good Lord made your eyes. So don't shade your eyes, but plagiarize, plagiarize, plagiarize. Only be sure always to call it, please, research. So the thing is that the notion of plagiarism, research, they are all in a way related. But there are certain points of distinction which has to be clearly emphasized upon. If you're referring to literature, if you're taking the idea from there, you can, because literature review is all about gathering ideas and try to identify the gaps in the existing literature and how your work is going to contribute to the existing literature. But acknowledge that. That's academic integrity. Don't pass it off as your own idea, right? And same is also applicable for legal scholarship. When it comes to legal scholarship, well, not just that the so-called other areas of studies are only affected by plagiarism, even ours area of particular study is affected. In fact, I would like to refer to the case of Easley versus University of Michigan Board of Regents. The Eastern District Court of Michigan in United States held that a law student who uses the words or ideas of someone else without proper attribution may be suspended or expelled from law school, unquote. So in this particular judgment, what we have seen is that the Honorable Court came very heavily on law students for passing off someone's idea as their own, and the penalty is also applicable if the same has not been an intentional passing off but a product of ineptitude or of an educational deficit. So the Honorable Court of United States, District Court of Michigan, to be very specific, came very heavily on law schools and the students of law schools. And it is not that only the legal academy is infected with this particular menace of plagiarism. Even judiciary, to be very specific, there was this instance of plagiarism from an honorable court in Philippines, and an honorable judge, Mariano Citel Castello, was accused of plagiarizing few portions of his judgment, which he believes to have been taken from Vinua versus Romula. Now, in this particular instance, what happened is that Justice Del Castello, he was accused of plagiarizing few portion of Vinua versus Romula judgment. And what was happened is that this matter went in front of the Honorable Court, and the decision on the said case was promulgated, and petitioner also filed for reconsideration. And prior to the resolution of such motion, the petitioner at that point of time, when they filed a supplemental petition alleging that the plagiarism on the part of the court, one report in fact quoted the petitioner's counsel saying that there is a very careful examination of stylistics of a particular pertinent portion of the judgment of Vinua, which will show that how cleverly the honorable judge has manifested intellectual theft. He has twisted the true intents of the plagiarized sources of that article in order to suit it with his argument in the judgment. So the honorable court in front of which this particular matter went at the later point of time, two questions were there. First and foremost, if Justice Del Castello was truly accused, he was accused, but whether he truly committed the act of plagiarism. And second, whether he twisted the works of the author in order to support the court's decision. The court addressed both these issues by holding the fact that a case of bad footing is there rather than one of theft or deceit. So it was not academic theft, it was bad footnoting. It was more of a matter which was concerning clarity of writing rather than ethics. And on second issue, which is whether he has twisted the words of the authors in order to support a court's decision, well, there was no misconduct on the part of Justice Del Castello. However, when I refer to the dissenting part of the judgment, which was authored by Justice Maria Sereno, she went to the extent of clearly highlighting, it was mentioned in his dissenting portion of the judgment, that a finding of plagiarism must be distinguished from the finding of a liability resulting from such plagiarism. In fact, in the same dissenting opinion, the issue of copyright infringement was also pointed out by the honorable judge. And she also extensively tabularized the instances of alleged plagiarism in the text of the Vinua decision side by side with the original source from where Honorable Justice Del Castello listed down so-called the supposed violations of the rules against the plagiarism committed. It was terrible. At the end of the day, the judge was held not guilty, but the dissenting judgment clearly gives you an idea. The same instance was also repeated in similar kind of pattern. In Indian judiciary, there are also so-called researchers, law clerks who are engaged in writing judgments, and many a times they do plagiarize. In fact, in Indian judiciary, which is also not insulated from this act of plagiarism, there are several such matters which came. In the matter of Gobind versus Madhya Pradesh, for example, the apex court of our country, in this judgment, which was matter of right to privacy, it was found to have lifted its word from the case of Paris Adult Theatres versus Slayton of Supreme Court of United States of America. Even a formulation of Kartar Singh versus the state of Punjab was taken from the excerpts of Granite versus Rockford judgment of the American Supreme Court. So even the judiciary is never immune, or I would rather say insulated from the act of plagiarism. Even that kind of thing happened in legal judgments, so-called not legal judgments, but to be very specific, judiciary. But before, since in the dissenting judgment of Del Castillo, the point of copyright infringement was also pointed out. But we should also keep something in our mind, that there are certain distinguishing features of plagiarism against the copyright infringement. Plagiarism is an ethical issue. Copyright infringement, on the other hand, is a legal issue. Plagiarism has been defined in several research misconduct policies, while copyright infringement are usually governed by national laws, federal laws. The definition of plagiarism may also extend to the ideas, while when it comes to copyright infringement, it doesn't. The element of public domain is included in plagiarism, but it is not in case of copyright infringement. Similarly, there is this fair use exception, which is available in case of copyright infringement, while when it comes to plagiarism, the fair use exception is not there. In case of serious violation of plagiarism, the consequences involve loss of reputation, job, etc. While when it comes to the case of copyright infringement, well, the statutory damages imposed against the violator is pretty much there. And the factor of expiry of work is not there in case of plagiarism. But if you refer to copyright laws in several countries, more or less you will find the expiry period is the life of the author plus 60 years or 70 years, as the case may be. And attribution is also a defense which is available in case of plagiarism, while this so-called the defense of attribution is not available in case of copyright infringement. There are several categories of the forest. Due to paucity of time, I will not get into the details of it, but I believe that more or less these are the classified. Classified in the sense that these are the classifications of the 5 categories of plagiarism. It may be copy and paste. It can be word switch, which we have seen in case of many such student research papers. Style plagiarism is also there. There's something called metaphor plagiarism, and there is something called idea plagiarism. Many other students I have seen they use right-click then, and then they use thesaurus, and without applying their mind the literary use of the term, they usually do that. Many times we do that. Many times we go for thesaurus to avoid using particular word repeatedly. I have seen that. I have also used several thesaurus words, and I also learn. You also strengthen your vocabulary, but you should also apply your mind whether this particular word is going to fit in that particular sentence, in that particular context. Many times students, they just don't that. They just don't. They just simply use thesaurus, they change the word, and they switch the word, thinking that it will not come under the track of. And you usually know, if you are engaged in teaching, you know how that student is, how that research paper is, and that language kind of appears to be very different from what you or she usually speaks or writes. So that also gives you, so that human element is definitely there. Now, when it comes to legal academy, to be very specific, just like other areas, promotion, tenure, salary increases for us also as scholars, as professors. We also depend, at least the part the professor's record should be reflecting original work as a scholar. And if the scholar is represented as an original, then of course it matters a lot. And when it comes to the law schools, the national law schools, which have access to several such online databases, they give everything. The exposure is huge in comparison to other colleges and universities. So they are in the first line of action to ensure, to teach academic integrity to the aspiring lawyers, the budding judges, and even the law professors, the future law professors. With the changing dynamics of information technology, what we have seen is that the legal research has also taken a very new kind of a shape. It's not that the old times when you have to go to library all the time and you have to request the librarian to give access to certain resources from some places. My professors used to go to other libraries and other places, like remarkable national libraries, for access to resources. But now it is not required even. In fact, you can just sit in your room and access it using online databases. So things have gone to that extent. So the challenges are also higher now. So identifying plagiarism is also easier in a way. Until and unless you have a good plagiarism software, it is difficult though, but it is easier if you have a good software, if you have good understanding of using that software. But I believe comparatively, plagiarism was also there when the softwares were not there. The traditional way of copying was there, but it was also difficult at that point of time to identify, because from which book or which journal you have taken and copied and pasted it, until and unless the reviewer is aware of it, it's very difficult, right? So if you're smart, if you're a smart way, if you know the smart way of plagiarizing things, then you would have easily evade the eyes of the reviewers. But now it is, I won't say, to be very honest, it's not difficult, but at the same point of time, the issue is there. One can evade even the eye of the reviewers or the plagiarism software, but it has to be very smart, unlike old times. So there are certain large number of softwares in existence at this point of time, which are pretty much available. Many of them are paid, many of them are free of cost. And like, for example, Turnitin is there, Urkund is there, Grammarly is there. So there are several such softwares available used to detect plagiarisms, and many of these detection tools have been developed by researchers. But still, they have some limitations, because one thing one should be very clear, that they cannot prove or they show evidence that this particular document has been plagiarized from another document or its sources. It only shows the similarity. It gives hints to some other documents. It never explicitly says that it has been plagiarized, because it knows there are certain gaps even in these softwares. When it comes to legal research, to be very specific, I have faced this with my students, with myself. For example, in our case, when we refer to a particular judgment, we refer to the operative part of the judgment, the obiter dictum of a particular judgment, and we have to refer that judgment, and we have to mention that in verbatim. And if we don't put in an inverted comma, and if we don't exclude the inverted, so-called quoted portion, then it will show as similar. The same thing is also there when we refer a provision of a law. When we refer a particular section or article of a particular act, or even the Constitution, we have to ensure that we are putting it in inverted comma. We have to ensure that we are quoting it properly. Otherwise, it will come wrong. But more or less, I have seen that it is, at the end of the day, application of mind, because no matter what the software runs, human intervention is required. Individually, I remember my university librarian, she put so much of endeavor. Ms. Konkana Boisha, who's also as an organizer of this particular event, she goes through all those papers, she runs all those papers, and she shares that with us. She also expresses concern. She ensures that they are complying with the UGC 2018 regulation. And on the top of that, we young researchers, or even faculty, we are in a better position to understand the software, but it becomes difficult for the learned, experienced senior professors, because they are not that well versed or accustomed, they're not that tech savvy. So we have to identify that if it has been shown as a copy, but it isn't, because that individual has cited, I'll tell you what happens. Now the thing is that many a times, Turnitin, for example, I've been using in comparison to Urkund. I have also drawn some comparative analysis with the help of my students, and I found that Turnitin is more effective at times with respect to Urkund, but there are also some good features with Urkund which is not there with Turnitin. But in a way, both of them are working to hone their detection mechanism. So what happened is that with respect to a particular paper, the student has cited a source of a book. And when I run it in Turnitin, and I found that in Turnitin, it was showing that the source, it was showing as copied. But the source that they have mentioned is somewhere else. It is, for example, this particular line, which my student has referred, is from a book by MP Jain. And when Turnitin runs it, it is showing that to be the original source is some student paper submitted in some university. Now, the thing is that when it comes to the Turnitin's own database, it usually keeps on its, the repository is usually like amalgamation of all the materials that they gather. And there they must have put that particular source of a student paper as the original. But the original source is different also. Over the period of time, the software also developed. Many a times, and this is the reason because of which they read that particular line as copied, but despite the fact that it has been cited. So individually or manually, we faculty have to exclude that, and then the similarity index goes on decreasing. So that manual intervention is there. Another thing is that if I listen to a video recording, YouTube lecture and I simply type that, provided that particular lecture has not been, or the minutes of that particular lecture has not been published anywhere in words, if it has not been, then I can simply listen to that lecture, type it, and publish it. The Turnitin software will not detect it. It is also unable to detect something which is scanned or something like that, but they're working on it, I believe. Now the thing is that that's why you need a Word file, and usually it is what you have typed to, and all these things. But I have seen many a times they are doing it. They're listening to a podcast and typing it, and if it's not there, that's what I'm saying, that if you know the smart way of it, evading it, it can be done. It can easily be done. But these softwares are also developing their detection skills. They are also developing their detection tools, because at the end of the day, these are softwares. These are softwares, and I'm sure that sooner or later they will address that issue. They will get over these glitches, because they are also learning in this process. They also get our feedbacks, our suggestions, and they incorporate that. They apply their mind, because it's all about coding. It's all about algorithms. So it's all human intervention at the end of the day. So these are the things that, despite you have these softwares, which is no doubt a very crucial equipment for researchers to identify how far their papers are properly cited, properly referred, not copied, not similar. It is very much crucial. It's very much relevant for even legal researchers like me to go ahead with plagiarism softwares. And many of these softwares, despite the fact that they are not in a position to identify materials which are converted from audio lectures, as I've mentioned, but sooner or later, this will be kind of taken care of. In fact, University Grants Commission of our country, that is India, UGC, Promotion of Academic Integrity and Prevention of Plagiarism in Higher Education Institution Regulation 2018, if you refer to Section 7, they have referred to the similarity checks of the plagiarism. And there they have mentioned that they should exclude the quoted work that has been reproduced with necessary permission, references, bibliography, table of content, acknowledgements, preface, and generic standard symbols. The law, of law and even standard equation should be excluded. So the fact is that UGC has taken these measures, and these are somewhere you will find that, because this particular regulation of UGC, the prime objective of this regulation of 2018 is to create awareness about responsible code of academic work. This is what the academic integrity is all about: to promote academic integrity, to prevent misconduct of plagiarism in academic writing, to establish an institutional mechanism to facilitate all these two objectives that I have mentioned. First, creating awareness; second, promoting academic integrity. So in order to do that, institutional mechanisms should facilitate. And thereafter, to also develop the systems to detect plagiarism and further set up mechanism to prevent such act of plagiarism and punish the student, faculty, staff, researchers, because UGC has prescribed several, if you see, there are several levels which they have prescribed, that if there's a minor similarities up to 10%, it bears no penalty, so-called level 0. While there are, when it comes to the common knowledge or coincidental terms, they have mentioned as 14 consecutive words. And if you go beyond that level 0 to other 3 levels of plagiarism, say level 1, 10 to 40%, level 2, 40 to 60%, and level 3 is above 60%. And accordingly, for students, they have prescribed a separate kind of a penalty. For faculty, they have, because for faculty, they have also targeted the increments, maybe 1 year annual increment or 2 year consecutive annual increment, or even restriction to supervise any research scholars for 3 years and so. And for student also, they have been given, like, you submit it again, you reject the paper if it doesn't comply with the standards. So this is what it is. So basically, I would like to conclude that this technical drawbacks of this plagiarism software will sooner or later be identified and fixed. But the core objective of the promotion of academic integrity lies in the ethical lines, and be it a national regulation adopted by a statutory body like UGC, or individual policy adopted by any law school or college or university, the ultimate goal should aim for a commitment to community ethos. And when it comes to legal scholarship, the law schools, they have to induct that sense of ethos amongst its fraternity, because tomorrow these people will be professors, judges, practitioners, and legal profession demands integrity, and to one shall attempt to attain the same. So this is what I have with respect to my paper. I hope I met the parameters of this particular seminar by presenting my paper. And I would once again like to thank Dr. Kankana Vaishya, to be very specific, for acquainting me about this online national seminar. And I would also like to thank the chairperson, honorable chairperson, co-chairperson, for presiding this particular session, and the organizers for wonderful, organizing this national seminar. And hopefully this will be an annual thing for every year, because I get to learn a lot from the librarians, those who are there, because they have access to wider information, oceans of information. And it's a great thing that I got the opportunity to present my interplay of legal research and academic integrity in this particular platform of librarians. And hopefully I'll also get this opportunity in the days to come. Thank you very much. Stay safe and have a nice day.